Late Friday, the Supreme Court blocked the Trump administration from deporting Venezuelan nationals under a 200-year-old law called the Alien Enemies Act. The court split 7-2, also emphasizing that everyone in the United States, whether they're legal or not, is entitled to due process. So that means notice that they're subject to removal and a reasonable amount of time to challenge the deportation in court, typically by filing a petition for habeas corpus. Now, Friday's case was brought by two unnamed migrants being held in Texas. The Trump administration accuses them and others of being members of the gang Tren de Aragua. The high court didn't actually weigh in on the merits of whether Trump can deport people using this law. That'll have to be answered another day. But all of this is happening as the White House is now considering or threatening to suspend habeas corpus. We actually did this WTF recently, but let's do it again now that the White House has opened that door. Habeas corpus is often called the Great Writ of Liberty, and that's a good name for it because it is a fundamental legal principle in a free society. Habeas corpus is Latin for you have the body, and it guarantees that someone who is detained, whose liberty has been taken away, can go before a court and challenge that detention and force the government to justify the detention legally. Think about it. Without habeas, the government could detain people and some would not have the ability to challenge it. That's not a free society. So now that you have the basics, enter Trump advisor Stephen Miller.
Well, the Constitution is clear, and that, of course, is the supreme law of the land, that the privilege of the writ of habeas corpus can be suspended in a time of invasion. So I would say that's an option we're actively looking at. Look, a lot of it depends on whether the courts do the right thing or not.
Let's go to the text, shall we? Article 1, Section 9 of the Constitution says the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. Now, that doesn't tell us who has the power to suspend the writ, and generally, it's been understood that Congress is the decision maker here, not the president. In fact, President Lincoln tried to suspend the Great Writ during the Civil War, but received so much pushback that he asked for and got the backing of Congress to do it. In fact, according to the Constitution Center, habeas has only been suspended 4 times in the history of our nation: during the Civil War, in 11 South Carolina counties overrun by the Ku Klux Klan during Reconstruction, in 2 provinces of the Philippines during a 1905 insurrection, and in Hawaii after the bombing of Pearl Harbor.